Hello students, there is a good news for you. Now you can write the same matter at different speeds. Link of the same is given in the description box. Thank you. Start. Section 139 of the Act merely raises a presumption in regard to the second aspect of the matter. Stop. Existence of legally recoverable debt is not a matter of presumption under Section 139 of the Act. Stop. It merely raises a presumption in favor of a holder of the check that the same has been issued for discharge of any debt or other liability. Stop. Para. The courts below, as noticed herein before, proceeded on the basis that Section 139 raises a presumption in regard to existence of a debt also. Stop. The courts below, in our opinion, committed a serious error in proceeding on the basis that for proving the defense, the accused is required to step into the witness box, and unless he does so, he would not be discharging his burden. Stop. Such an approach on the part of the courts, we feel, is not correct. Stop. Para. An accused, for discharging the burden of proof placed upon him under a statute, need not examine himself. Stop. He may discharge his burden on the basis of the materials already brought on records. Stop. An accused has a constitutional right to maintain silence. Stop. Standard of proof on the part of an accused and that of the prosecution in a criminal case is different. Stop. Para. Furthermore, whereas prosecution must prove the guilt of an accused beyond all reasonable doubt, the standard of proof so as to prove a defense on the part of an accused is preponderance of probabilities. Stop. Inference of preponderance of probabilities can be drawn not only from the materials brought on records by the parties but also by reference to the circumstances upon which he relies. Stop. Para. A statutory presumption has an evidentiary value. Stop. The question as to whether the presumption whether stood rebutted or not must therefore be determined keeping in view the other evidences on record. Stop. For the said purpose, stepping into the witness box by the appellant is not imperative. Stop. In a case of this nature, where the chances of false implication cannot be ruled out, the background fact and the conduct of the parties together with their legal requirements are required to be taken into consideration. Stop. Para. We are not oblivious of the fact that the said provision has been inserted to regulate the growing business, trade, commerce and industrial activities of the country and the strict liability to promote greater vigilance in financial matters and to safeguard the faith of the creditor in the drawer of the check, which is essential to the economic life of a developing country like India. Stop. This, however, shall not mean that the courts shall put a blind eye to the ground realities. Stop. Statute mandates raising of presumption, but it stops at that. Stop. It does not say how presumption drawn should be held to have rebutted. Stop. Other important principles of legal jurisprudence, namely presumption of innocence as human rights and the doctrine of reverse burden introduced by Section 139, should be delicately balanced. Stop. Such balancing acts indisputably would largely depend upon the factual metrics of each case, the matters brought on record, and having regard to legal principles governing the same. Stop. Para. Many statutes shift the persuasive burden. Stop. it has become a matter of routine for Parliament in respect of the most trivial offences as well as some serious ones to enact that the onus of proving a particular fact shall rest on the defendant so that he can be convicted unless he proves it.